Okay, good afternoon, welcome. This is the Buncombe County Board of Adjustment. My name is Jim Lesko. I'll be chairing these meetings, and I will ask the members to introduce themselves. George?
George Lycan, South Asheville.
David Summey, South Asheville.
Jim Guido, Beaver Dam.
Peggy Mann, Limestone.
Robbie Taylor, South Asheville.
Lisa Stevens, South Asheville.
You all received a copy of the minutes of the March 14th meeting. Are there any corrections? Hearing none, the minutes will stand as submitted.
Can you turn your microphone on?
It is on.
No, it isn't. It's on.
There we go.
Thank you. Today we're going to have 3 hearings, and they're going to go in this order. The first one, Nathan Bryant and Samsel Architects, because that required public notice. That one's being taken first. We have continued hearings. The second one will be Robert Ward. And the third, Danny Whitted has applied for a variance. So they're going to go in that order. And as Jillian said, these may be a little lengthy, so if you want to step out of the room, but we don't know whether they're going to be lengthy or not. So we may be here for a little while today. Okay, if you're going to speak today, you have to be sworn in. So I would ask you at this time to come forward, and one of you put your hand on the Bible or one of those, and then put your hand on the shoulder of the person next to you.
Is this for the entirety?
Entirety.
Yeah, this is everyone, we hope.
For all 3 cases?
For all 3 cases, yeah.
Left on the Bible. Left.
Yeah.
Left hand.
Your other left hand, yeah. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God? I do. Okay, you may be seated. Okay, Josh?
All right, Mr. Chair, the first case that you have before you is ZPH 2012-00006. Nathan Bryant and Samsel Architects have applied for a variance from Section 78-646E4, the Protected Ridge Overlay Building Width Standards of the Zoning Ordinance of Buncombe County, to site a single-family home on tax lot PIN number 9750112031 at 6 Reuben Road. Mr. Bryant has also applied to establish a 5-year zoning vested right for the variance request pursuant to Section 78-622B of the Zoning Ordinance of Buncombe County. I'll reserve my remarks until after we hear from the applicant so I can provide any clarity, but I will say that the variance and the vested right stand as 2 separate action items that need to be approved separately from one another.
All right.
Josh.
Who will be speaking for the...
Yes, my name is Nathan Bryant with Samsel Architects. I'm here today on behalf of my client, Grant Hellier and Carl Gibbons. They bought their property several years ago with the intent of building their retirement home off of Patton Mountain Circle. They hired us in 2011 to begin due diligence, and upon due diligence we saw the difficulty with regard to some of the new provisions of the zoning ordinance. So we developed a plan that we felt was very modest and provided the least amount of impact to the site. The challenge with this geography and geometry of this lot makes it pretty difficult to fit a site on the upper end of the property. The property is only 75 feet, and it tapers outward as you go down the slope. So we managed to work within every other provision of the zoning ordinance, and really had a hardship fitting even a modest house within a 30% width of the lot. as you can see, there's only 22 feet left at the upper end of the lot. So really, that's the portion that we're asking for the variance on, and feel like that's going to provide us with the lowest impact on the site, the least amount of impervious area, the least amount of disturbed area, preserving more trees where we've got it located. Got a few more exhibits to hand out to show the section of the site. Really demonstrates the difficulty of moving this farther down the hill.
Yeah, this is.
Could you explain that 22 feet?
Well, the ordinance requires us to stay within 30% of the width of the lot, and at the upper end of the lot, at the uphill portion of the lot's only 75 feet wide. So 30% of 75 is only 22 feet, which is not really even wide enough to put their garage. So that's where we.
In other words, the ordinance says that your house should be 22 feet? Is that what you're
30% of the lot width, which
saying? The upper end.
equates to 22 feet.
I see what you're saying.
As you work downhill, the allowable width would increase.
It does, and we looked at locating the house farther downhill, but on a 43% slope, we couldn't get a driveway down to it.
I see the problem.
It looks like the farther you go down, you're not going to get wide enough to build that house anyhow.
You'd have to. I think we could squeeze it in way down at the bottom end, but
Yeah. There's a house already there.
so we took cues from the other houses on that street that were closer to the patent circle. That took advantage of the 15-foot setback, and really tried to follow precedent on that street with the other houses.
Have there been any comments from the neighbors?
There have been comments from the neighbors, but I believe they're represented here, so I'll allow them to make their case themselves. I also note that this house, at 43% slope, Beaver Dam has a variable setback. So on less steep portions of the property, you're required to be further back from or less steep properties are required to be further back from the road. On this one, it allows you to go up to 15 feet from edge of road, essentially to encourage a lesser installation of impervious surface. So that is one of the factors in play at the site. There are also, in terms of fronting requirements, there are also provisions within the zoning ordinance that would normally allow you to align the houses to other houses on the street, but since this is a unique zoning district that's compounded by the overlay, those particular sections of the ordinance are not applicable to this particular case.
Any other questions?
Are there any structures currently on the lot?
There is a small cabin at the far downhill portion of the lot.
Okay.
It actually straddles the property line of their adjacent property.
Right.
Our
Okay.
applicant owns another.
The adjacent?
property.
Okay.
Is there anyone else that would like to speak on this variance?
We have two people signed up, and the first one is George Sanger.
name is George Sanger, and I'm here on behalf of Mr. and Mrs. William Means. And they are the neighbors immediately to the west. And if I may, I have an affidavit from the Means along with a GIS overlay. And I only have 5 copies.
I'll scan it out.
Yeah. Why don't you take that, and then I can look on with Peggy here. And then we can-
One more down there, yeah.
Just make sure someone gets
Right.
Yeah.
Mr. and Mrs. Means oppose the granting of the variance. I think the first thing, if you would look at this picture, what I think is important to note that the applicants actually own more property here than just this lot. They own, and I've highlighted it in yellow. This is the lot they're applying for, which you'll see has the existing structure on it's the lower side of it. They also own the 3/4 of an acre lot immediately to the near the top of this GIS map that also has a residence, and then that small triangular shape blue section there. But they bought all that at the same time when they bought their property. The Means have no objection to them building a house within the parameters of the ordinance, and we would suggest that they already have a home. They could either expand that, or if they want to tear it down, build at the bottom of the lot and come up from the bottom. The slope is pretty much uniform, it appears to me, as you look at the topo lines. If anything, it's steeper at the top. But you'll also note from their lot, and I also have a survey of just their property, you can see how their house fits well within the concepts of your frontage, 30%. They've got this space here and then on each side, which they believe, they support the ordinance and they believe they've complied. And if you look at the pictures that are attached to the affidavit, they've tried to show you what they expect what would be lost by cutting this frontage and for access from the top, be the very trees that are there now, because this is such a narrow frontage of only 75 feet. So and you're welcome to look through those pictures, and if you have any questions, I'll be happy to answer them. But they would suggest that the intent of the ordinance would not grant or not allow for the grant of this variance. The applicants already have a home on the lot. There is good access from the bottom. They could build this house from the bottom up. They could push the house up the lot, but access it from the bottom and fit within the parameters of the ordinance, and do much less damage to the property that's adjacent to the Means and on the other side as well.
I'm sorry, which other lots did you say that they own? Because we
Okay.
don't have that.
If you look at this, this is the lot they're applying for, and this is the existing house. They also own this lot here, which is 3/4 of an acre, that house, and they own this little piece in here. This is Reuben Road coming up, and
What
this
is this, a right-of-way, or is that
Yeah.
somebody else's land?
No, this is their access for this home as
Okay.
well as this home.
Okay, all right, thank you.
Can anyone give me the numbers on that so I can see? Can anyone see the numbers that are on here that?
No, there too.
No?
Yeah.
Well,
Is it like the 14323?
the 3-1, I think it's
And is this one here?
this one.
This one?
This one,
That's what I
and
thought,
this
that
one.
one. Okay, this one, and this one. Okay.
Correct.
They own all of this.
So this one?
I see they own this blue
And this
They
outline.
own that one, and then they own this one right here, and then this is the one
Yeah,
they're
this is the one
requesting
we're
the
talking
variance.
about.
Right, and Mr. and
This
Mrs.
is Means there.
This is their home.
They own, the applicant owns this
Is there any-
and this
We should ask
triangular
them if
lot.
we have any
Correct.
restrictions to consider that.
They own the house that's on that triangular lot.
Yes, sir.
Do we have a lot of latitude? I mean, it's 3 separate properties. Just they happen to be owned by one person right now. Yeah, I have a question just in terms of like, how much latitude do we have to consider the other properties? Because it just so happens that's one person who owns it.
I mean, if you consider this from, if you have a developer of a subdivision coming in,
Yeah.
who at that time owns the entire subdivision, then you're saying you would be setting a precedence in this case that, well, they have, 40 other properties within the subdivision, and
Right.
perhaps they could build elsewhere. The lot creates the hardship, not individual circumstances. Just like we're not allowed to consider economic difficulty as a means for hardship, I don't believe that we should consider economic prosperity either.
I would concur. I would recommend that the board focus just on the lot and the
On that
building
lot.
application as to the lot and not
Okay,
Okay.
okay, thanks.
how that works.
Again, the facts are what they are, but it looks to me, and from the Means point of view, that this lot never changed from the time the applicant bought it, and there was always a house on the bottom. Access was always from the bottom, and that's why we think to reorient this lot entirely to the other side, and then seek a variance when the lot is really, never was suited for it, would not be appropriate. We have no problem, the Mr. and Mrs. Means, of them putting a house in there, but within the parameters of the ordinance, and preferably with access from the bottom.
I will clarify for members of the board that if you look at the exhibit that was provided to you by Samsel Architects, it does show a right-of-way at the top of the property, so perhaps Mr. Bryant could clarify as to whether that's a valid access for the property.
Well, and that is a good point, because the applicants were not granted a right-of-way, and I think there's a serious question whether they have any right, because the road at the top, Patton Circle, is a private road. My clients were granted a right-of-way. The Hillier and Gibbons lot was not
It's
granted.
depicted as a right-of-way on the plat.
Survey shows it as a public right of way.
Well, it's a private road. It's a private road.
Well, and I would just caution the board that is not really an
That's not our
issue
issue,
for
yeah.
you all to decide whether it's a private road or, I would say that for purposes of our decision, there's a right-of-way. If it's not, it's going to be on the applicant. If it's not a valid public right-of-way, it's going to be on the applicant, but that's not really what we're deciding here today.
Okay.
Mr. Sanger, there, in this submission that you made here, there are many comments in here about trees being taken away, or mature trees next door, subject property. That seems to be the issue in these, rather than where the house is sited on the lot.
Well, I think the fact is, but they go hand in glove, because they're going to take so much of this 75 feet, they're going to have to take all these trees off the
Right.
top of the lot. Yes, sir.
Okay.
No, I think what Mr. and Mrs. Means are saying, they like their house, it complies with the slope ordinance, they'd like their neighbors to comply with it, but they know that they want to build another house, they don't object to that.
So they feel it's going to alter the character of the neighborhood.
They do. Yeah, you have all those trees now, you'd have to take them all down between the Means house and Mr. Friedman's house. You pretty much have to take those all down to have access and for a building site.
Mr. Sanger, we're
Yes,
going
sir.
to need a copy of that survey that you referenced, I guess at the Means property.
Sure, I'd be
That is
happy
on the
to.
record, thank you.
And just to clarify for the board, in terms of the conformance of the Means residence to the existing protected ridge overlay, we cannot confirm or deny that as members of staff because it was built prior to the overlay, so it has not been evaluated as such by staff. In addition, this property will be subject to replanting requirements on the downhill base of the lot that takes into account the planar surface that would be visible. So there will be some replanting that takes place as per the ordinance requirements.
Was the protected overlay in place when they purchased the property?
No, the protected ridge overlay, in my recollection, is, excuse me, it was October 2010 was when it was installed, so I believe they purchased the property prior to that.
Does staff get any input from geotechnical people regarding colluvial soil?
Correct. This particular property will be required to undergo both a global stability index or analysis, as well as an evaluation by a geotechnical engineer pre-construction, as well as undergoing follow-up post-construction.
So the flow could be that this variance could be approved, and in the flow forward, the geotechnical people could find a number of things, or at least one thing that might not fit the requirements, and that would be a showstopper.
We don't have any specific requirements in terms of geotechnical engineering reports, just that the geotechnical engineer displays some level of comfort with the house design and specifically evaluates the way the house is designed. Just for illustrative purposes, what we typically see is they modify standard footer depths, say you need to go this depth on footers, or they install specific drainages on the site to keep the water away from structural portions of the house, and then we require that they inspect post-construction to ensure that that's been achieved with the construction of the house.
Another question is, there is some remarks about that ordinances have changed since the property was bought. Is some guidance you could give us about in what manners that has impacted this?
No, it really doesn't. I mean, really the question is if you own a parcel of property,
Right.
you have no, right that the zoning's going to stay the same forever. So the zoning may change.
Okay.
At a later date. The question is in this case, since they're allowed to build a single-family residence, if that
Yes.
it probably is a non-conforming lot. The question then is whether or not they need to comply with the setbacks and the other requirements of
Yes.
the ordinance. But they are allowed to build a single-family residence on this lot.
Right, right.
And we do allow two primary uses by right on single-family lots, which would include two residential structures.
Okay.
All right. Did I see someone else who wants to speak?
Well, she's got.
Friedman was the next person who was signed up. And
Okay.
just a note
Oh.
for everyone, if you show something to the board, you need to provide it to me.
Afternoon.
Good afternoon.
I own the property to the east.
And your name is?
My name is Fred Friedman. And I own the property immediately to the east, so we have a shared property line. I could just spread these out for a moment. Okay, I will state right off that I am not opposed to another house being built on that property, as long as it conforms to.
Mr. Friedman, you
Yes.
need
Have to sit down, yeah.
Oh, okay, sorry. I'm not opposed to another house being built on that property. I understand the zoning ordinances, but I am opposed to the variance being asked for on this. There's a number of issues, and if I might go through them one by one, this may take a while.
It's all right.
But I would like to start off by saying there's been a lot of emphasis put on this lot frontage being 75 foot. The original plotting of this little development, that lot line was changed by the owner illegally years ago, and I spoke to Mr. Coleman, and the property was put back together. The Means property actually had been divided into two lots, and that was an illegal separation, and they went down with an unrecorded plat and got PIN numbers for them. Years later, after I bought my property in, I believe it was 2004, Mr. Morris put the lots up for sale, and I went down to zoning, and Mr. Coleman at that time got in touch with him, and he had to put the lots back together. But when he put the lots back together, he changed the 120-foot frontage to 75 foot. I have plats of the original, or I could refer you to them. Can I bring this up?
Then it becomes,
Yeah.
It just becomes ours.
it becomes ours if you
No,
bring
I
it
have
up.
copies of these.
Okay.
So, do I present it, or you? Okay. This was the original, this is the right-of-way coming in. This was the original lot that is asked for the.
Mr. Freeman, you need to speak in.
Oh, okay. This is the original lot that was platted back in 1972. This was the other lot. My lot was number 1, this was number 2, this was lot 3, which then was subdivided illegally into 2 lots, then put back together. When it was put back together, they changed this property line.
Okay.
Okay? So I want to refer to that issue.
So now we're talking
Why,
about,
why do you say it's
talking about
illegal?
this.
Well, because this, by the requirements of zoning, it called for a certain area. When the certain zoning regulations were established, this was a non-conforming lot by area, and by dividing it, they made it less non-conforming, which is illegal. They were buildable. This lot was always buildable, but you had to meet. I'm very familiar with the zoning. I've been dealing with this since I moved here.
Did this have to go through the Beaver Dam? Did
Well-
they have to approve it?
I think the issue, Mr. Summey, is that I'm not sure which one you were looking at, but the Means property was actually divided into 2 lots, and it didn't conform with the minimum lot size at that time. There was also a recombination where they shifted the lot line. It's the division of the Means property that was an illegal subdivision, but the recombination, from my understanding, does not present any issues of legality. It's a shift in lot line, which we do on a pretty standard basis, as you're well aware.
So we're saying when it was put in, because of the steepness, et cetera, when you put it into 2, it became too small of an area, right?
Correct, for the Means
Okay.
property, and then it was
Okay.
recombined through Mr. Friedman's efforts and bringing that to the department's attention.
Okay.
Mr. Chairman, I don't mind him referring it to the Means property, because that's who owns it now, but the Means didn't have anything to do with that.
Correct.
Okay.
Okay, Mr. Morris is the one, and Mr. Morris is the one that sold it to the people that are wanting to get the variance now.
The Bryants.
The Bryants, okay.
Okay.
What I would like.
The Bryants, so we're
Bryants.
patently clear here. The Bryants didn't have anything to do with this combination and
No,
recombination.
but,
Okay.
no, but I'm going to refer you to something in your ordinances, because there's been emphasis on the frontage of this lot. People keep talking about that it's a small frontage. It's only 75 feet, okay? Who do I give this back to?
Put in
You
his
can
hand
take it
right
with you.
back. Take it with you.
All right, I'm going to go to the subdivision ordinance, section 70. (7010) on variances. And in the second paragraph, it says, a variance may also be proper when environmental concerns are viewed in light of the spirit and intent of the planning ordinance. Such requests may be made by the applicant or any of the planning board. Upon motion of any member of the planning board, the 30-day requirement may be waived. Variance will not ordinarily be granted if the special circumstances on which the applicant relies are a result of the actions of the applicant or owner or previous owners.
This is referring to Chapter 70, and the variance
I know, yes,
is
exactly.
a variance of Chapter 78. So we're mixing
Well-
2 different ordinances at this point.
But it's referring to, this was a subdivision of property. These were platted lots. The reason I'm bringing this up is because everyone's making an emphasis about it only has a 75-foot frontage. The previous owner created that situation. And this, in the subdivision ordinance about your properties, says that's nothing to, be considered. So stop talking about the 75-foot frontage. That's what happened when this person divided the lot and then put it back together and changed the lot line. That's my point there.
Just a point
Yes.
of clarification.
Yes.
We aren't measuring the width of the house from the frontage. We're actually measuring it from the downhill facing portion of the structure exclusive of the porch. So I'm not sure, and maybe Mr. Bryant can clarify if the frontage really plays into this variance request.
Why don't, Mr. Chairman, if I might make a suggestion, why don't we let Mr. Freeman complete his
Right.
Presentation,
and
yes.
then we'll go from
Okay.
All right, if I go through this request for variance, looking at the size of the house that's being put on that lot, my understanding that the back line of the house facade, at what the width of that lot is measured, can only be 30% of that, whatever that line is, as the back side of the house. So it doesn't pertain to the front side. Am I correct in that, sir?
Just finish your presentation.
Okay. Well, that's my understanding in conversations I've had. So we measure the back line where the back of the house falls on the property. And by this scale on the plat that's been presented, the site plan, I get a measurement of approximately 108 feet. The house across the back side on that plat, including the porch, is approximately 66 feet. Allowable, based on the 108 feet, would have been a 30-something, just a little over 30 feet. They're asking for a 66-foot across backside, which is 100% more than what's allowed. I strongly oppose that. I will say that the access to that property has always been from Reuben Lane. There is currently a house that's been on that property since 1972. I have the building from building, and I'll give this to you. I know there's something in the variance here that asks about, like, what kind of, let me see if I can find it. The uphill, let's see, indicate how, if the applicant or property owner complies with the provisions of the article, meaning staying to that 30%, that the owner seeking the variance can secure no reasonable return from or make no reasonable use of his property. He has current use of the property. There's an existence residence on there that has been there since 1972. The planning department or the building department has the property valued at $144,000, which he's paying taxes on. So to say that it would have no value if he can't get this variance is absurd. I'd like to submit this to the building department.
All right. I'll pass that down to Jimmy.
Again, that property has been there since '72. Access to that property has always been from Reuben. And I
Mr.
believe-
Friedman?
Yes.
We're dealing with the here and now,
Okay.
not what's has been.
Okay.
And if you could confine your remarks to
Okay.
specifically of here and now, we would
Okay.
appreciate it.
All right. One of the other statesmen talk about the unusual geometry of the lot. Well, I got to tell you, every lot up there has an unusual geometry. Okay. Building the, there are certain, under that ordinance, it talks about allowable disturbed area and allowable areas that cannot be covered because of, what is the word? permeating soil. Moving the house further down the lot, there's plenty of flexibility there within the ordinance to allow the building of the house down further on that slope. He has the house oriented parallel to Patton Circle. The house doesn't have to sit parallel to the front of that road. It could run more down the west side line. I am the one that's going to be most impacted by this because he wants to build 15 feet from that lot line. My house sits approximately 22 feet from that lot line. The means on the other side, from their house to the lot line, is 65 feet, and then there's the 15 feet setback, which is going to put their house 80 feet away. This is going to put their house approximately, 35 feet from mine. And if you look at the neighborhood, this would probably be one of the closest house to any other house in the area. There's a lot of spacing around there. There are a cluster of roundettes down in that section. My house is a roundette. One up on top of the hill is a roundette. So it's not conforming to what is there. Staying within in what's called for would give more room on either side. And certainly, I believe they could design a house that would fit. To me, it looks like the house was designed, and then let's see if we could stick it on the lot, as opposed to, this is the parameters we have to work with. Let's design something that could fit there.
Can I object to speaking?
Just let's get him finished, and then you can.
You'll get a chance to read,
Yeah.
to rebut what these are being said. We're just trying to get through this.
Okay, so anyway, getting back to that, there's a great flexibility within that lot by the ordinance that's proposed. I mean, that this falls into as far as the area they can disturb, and then that area that's left that, can't be built on. So there's plenty of room there. Let's see. Okay. Now, one of my key points is, and I thought that this plat is supposed to show a true, thing of what's going on with that property. I would like to present to you a easement agreement to MSD from the previous owner, Mr. Morris, that was signed in 2000, and I will give you a copy of that, which calls for, there's a sewer at the top of Patton Mountain Circle there that provides sewer for the upper property, my home. It's a sewer line that was private originally, but it was taken over by MSD years ago. There was a rehab project that has never been finished. The lower section, back in 2006, some work was done on it.
If I could just interrupt you, easements are completely out of our purview, right?
Well, it pertains to
Mr.
this.
Freeman, if you could, do you think, just to simplify this, could you just tell the board why you're against the granting of the variance? Because we're really going into topics that the board has absolutely
I'm going to tell you, if you grant a variance based on this site plan, which allows it, it puts that house in an easement agreement that's been signed. That's where I'm going.
That would be between
That's
the new
between-
homeowner
and Buncombe County building permits.
whoever's with that agreement. We're not
Whoever's the other
considering
party
that
in the
stuff.
easement.
That
That's
doesn't
there's
have
nothing
anything
to do with us.
Well, it doesn't allow a house to be built in an easement.
That is
That's between
completely
the-
out of the board's purview. That is a private contract
Can't judge
between the
Yeah.
between the people. If they violate the
So
easement,
you can grant a variance and say, build over there, and then.
we're not.
We're
We're
not
just
granting them
saying
the
that
right
they
to
can
build.
they can get a zoning permit.
Well,
We're
I
not
would like
saying
to-
that.
I would like to enter this.
Please
document.
feel free, sir.
Yeah, we'll take it, but
This is the property. This is Patton Circle.
Mr. Friedman, if you're gonna speak up there, you need to speak into the microphone.
Okay. All right, this is Patton Circle. This is the property line. This is where I am. There's a 10-foot permanent easement, and then there's a 15-foot construction easement. 25 feet from that property line is a registered, recorded easement with MSD. So they should not be allowed to build within 25 feet of that property line.
Okay, we understand what you're saying.
All right.
We have no purview.
Well,
in that
that's
area.
why I'm opposed to, that's one of the reasons I'm opposed to the variance, because you would allow something to be built in an easement where a sewer line has to be repaired, and that's going to affect it. Again, looking at these. No, it's on. It's on. I'm reading this. Adhering to the it says indicate how the variance is the minimum necessary to afford relief. It says adhering to the 30% of lot width limitation does not allow for construction of a modest footprint 1,600 heated square feet plus 2 garage. Well, when Nathan spoke earlier, he said a modest 1,600 square feet home. Well, that's different than what he's saying here. He's talking about a 1,600 square foot footprint plus a 2-car garage, which to me that comes out to around 2,000 square foot footprint to start with. And they're calling for a 2-story house. So I don't know what one calls a modest or by whose definition. So I would maybe give some rethinking to that. I've looked at many things online as far as building on narrow lots. I've got loads of sheets that here that I could hand to you of homes that are 30 foot in width, wide, and can be deep.
Mr. Friedman, let's stick to the specifics of this argument.
Okay.
We all give general, we know what the ordinance is,
Okay.
and we're trying to say, does this property fit?
All right. Well,
Not a
there's
general case.
no reason that a house cannot meet the ordinance. By virtue of the building height, you're allowed to have an average building height on this house of 35 feet, as opposed to 25 feet because of this of where it sits from the top ridge of the distance it is from the higher ridge. So 35 foot would be allowed. So theoretically, you could have a 25-foot frontage, 20-foot height on the front, and a 45-foot in the back.
Mr. Friedman, stay away from the theoretical. We
Well,
want to
I'm
deal
just
with the
saying
specific.
it would meet the standards of what's allowed in this ordinance, is what I'm trying to get at.
I think, let me say, because we have to use a certain language.
Okay.
Let me try to say what I think your points are and see if you're in agreement, okay?
Yes, sir.
I think what you're saying is that, one, you think there are options available that could be done which still fit the ordinance and you don't need variance. Is that one of your points?
That is correct, sir.
And the second point you're making is that since they already are existing in a situation where the use of the land is already happening in a way in which there is return and use, that you do not feel that the hardship thing applies because it's already functioning without that you're feeling that they're creating the hardship doesn't exist in and of itself.
That is correct.
Is that two main substantive points you're making?
Yes.
Okay.
Yes.
And that's, I see, because we can't go into all the details. We just need to know what the substance of your premise is. Have I missed anything?
No, I believe that is
Okay.
correct.
Okay.
Let me just see if there's anything else I want to give you here. Other than the fact that, like I said, I am going to be the most impacted if you do give this variance, because it's going to put the house right close to me, and it's going to be closer than other things in the neighborhood. If you drive through the neighborhood, even with these little clusters of houses, there's still greater distance between them.
You are the dual rondette.
Yes, I'm on the east.
There's two rondettes are,
Yeah.
okay.
Yes. Right, they're joined together, and I believe the square footage is around 1,600 feet overall. It's a one story, and it does have a unfinished basement in it. And I don't know what they were going to, by talking about the difficulty to build further down the lot. I mean, I'm not clear about that, because my house is built from, is 10 foot below the street level at the, that corner of the lot where you see the sewer at that property line. My house is built 10 feet down below that level.
Okay.
Okay. Does that conclude your remarks?
Yeah, if you're saying that you don't want me to address things that are in another section.
Well, really, we just need to have, is there anything of substance, a concept area rather than details and hypothesis? Is there anything of substance that we can really consider?
Let me just, okay, I guess that'll be it.
Okay.
I do have other things I was going to say, but if we don't want to pay attention to the subdivision ordinance, it won't make any sense.
There may be an avenue for that, but this is not the vehicle for that. It's not our purview.
Okay. Well, I just don't want something to be built or allowed on that variance. Now, I understand that you can make, within ruling on the variance, that you can make some exceptions within it, or putting guidelines within it. Okay? If you do give a variance, I would ask you to consider the placement of the house on the property to my property line, since there's so much more separation on the other side, and to consider
So you would have
agreement.
concerns regarding buffers and those type of concepts?
Yes.
Okay.
Yes.
That's a
because
substance.
within that easement agreement,
Right.
they cannot plant anything in the permanent easement.
Oh, okay.
It's all stated in that agreement
Okay.
if you're willing to look through it.
Okay, Mr. Bryant, I think you said you wanted to speak again?
And Mr. Chair, if I could just
Yes.
hit a few points while Mr. Bryant's getting ready to speak. If you'll refer to the site plan provided by the applicant, it still meets the 15-foot setback required by the Beaver Dam zoning. The issue is the 30% lot width, which we have two sets of what are appearingly setback requirements, and I will say from an intent standpoint, as a member of staff when we wrote that ordinance, that the 30% is written largely as an aesthetic guideline to prevent the ridgeline from having compressed housing as you look up at it. It still does have some setback issues that are built into it, but they're still adhering to the underlying setbacks within the Beaver Dam zoning district.
Okay.
I'd like to address a few of the points made by some of the neighbors. I have a letter from the homeowner's surveyor that's states his consultation with Mr. Friedman's surveyor, and they corroborate the survey as submitted as correct and legal. So I'm going to...
They actually have a copy of that already.
Yes.
We do. Yes.
So that's what we've got to work with. If there are other issues, we've got a stamped survey, and that's all I can work with at this point. As far as I can tell, the 30% lot requirement also goes hand in hand with a 200-foot lot width provision. Correct me if I'm wrong. So I think some of the intention for the 30% lot width is intended for lots that are conforming at the 200-foot width. Now, this lot being platted a number of years ago is non-conforming in that regard. So I think from our vantage point that the 30% restriction is intended for a lot or a type of lot that's much wider than our applicants. As far as the setback from the street and its location on the topography, we're just asking to do what the two immediate neighbors did and build closer to the road to limit the amount of disturbance. That's all we're asking to do is do. It was done for good reason for those two houses, and it's to limit the downhill disturbance, and that's what we're asking to do here. And to address other configuration options, we did look at many other configurations, and again, at the 43% slope, it's impossible to get a driveway down to a lower point on the lot.
Can you come up from the other road with a driveway?
It's very steep coming up the other side, too. So adhering to the setbacks on the downhill side, if we were to adhere to those, we're still coming up 43%. So again, there's a reason the other houses were done that way, were built that way, close to the road, on the uphill access. And that's what we're asking to do as well. I'll just close by saying a lot of things debated today that maybe aren't open for debate. My client has every right to build a house here. They bought the property with the intention to do so. And we'll do our best to work within the zoning ordinance, and feel like we've done so and provided the least impactful solution to building a modest home. Thank you.
I'm sorry, sir, I didn't get your name again, but is what you're asking the variance to be as depicted on the site plan, which is the plat that you have?
Correct.
So the house would be built in accordance with the survey that you all have?
Correct.
Okay, I just wanted to be sure of that, so it would be as depicted on it.
Correct.
And this would be exhibited for the vested rights. It would go into the record.
I guess that would be the site, is that that's not a recorded plat, but I guess it would be the survey shown by Samsel Architects.
I've got a recorded plat I can submit.
Right, but that doesn't have where you're building.
Correct.
We're talking about the site plan going in as an exhibit to the vested rights and the variance.
I just want to make sure that we have a visual representation that's also been surveyed out so that we're not dealing with, that you have to be X amount of feet from one, that everything's on the plat as needed.
Okay.
Mr. Bryant, in your professional opinion, I think you mentioned that the solution you found puts this property in the optimum conformance with the adjacent properties. Is that what I heard you say?
The optimum, from a logistics standpoint.
Considering the situation.
Right. It is. It's the best spot for access. Again, the driveway on a steep slope is impossible at 43%. And there's a reason you see a lot of the houses built on these steeper slopes closer to the road. And there's a reason the ordinance allows for that on a steep slope for the house to be built 15 feet from the road. So, yes, in my opinion, that's far and away the best and most logical and logistically appropriate place to put the house.
All right, anything further from Mr. Bryant?
I just have one quick question. So if they are not allowed to build with that variance, there's no other place on this that you could put a driveway?
No, again, coming up from below, we've got to adhere to setbacks if they were to build a house on below. And this is a 43% slope, and that's just not practical, and it's not stable to build a 43% driveway. So coming up from below, if we want to talk about global stability and stability of the slope and impervious area, that's a worse case than coming in from above. The house acts as a retaining wall above so that you can minimize approach on the uphill side of the house.
Could you tell me what condition this lower house is in? Is it livable? Is it a good house?
It is, but it's was bought with the property. It's a small cabin, so it's not the intention of what my client wants to.
It's a two-story frame.
It's a two-story frame, but the lower level has like a carport that you pull under. It's a small structure, and it does not meet the programmatic intention that my client has for their retirement home.
The what kind of intention?
The program, the program being what rooms that they want, what access that they want.
Okay.
And I'll defer to legal counsel, but
We can't consider that.
I think we have to be very careful about our discussion of that second home, since two homes are allowed on the lot by right.
Right. Okay.
I agree. I think what you all need to do is basically picture this as a person who wants to come and build a single-family residence on the lot and focus solely on that issue, and not that, well, they do have a home down at the bottom, because they're not required, they're allowed to have two structures on the property.
Mr. Bryan, is there anything else from you?
I think that's all I've got.
All right.
Thank you.
Jillian, is there anyone else?
There was no one else who was signed up.
There was a hand up back here.
With Mr. Friedman, so if you'd like to let him speak again.
Yes.
The issue to me is not the 15-foot setback off the right-of-way on Patton. That's never been an issue to me. I understand the zoning. My question is the width of or the size of the house that's trying to be put on that property. You can go down the lot line, meaning build a narrower house and go down the property. Also, they're talking about a 43% drive. The drive doesn't have to go straight down in front of the house. You can traverse the property coming in from one side and going across, which means you don't have an angle coming straight down into your house. I don't know what the plan is for the house, if they were going to try to have the house up at the street level, or the house was, like I said, my house sits 10 feet below the top grade there. So I don't know, I haven't seen the plans. You know, if they're going to put a retaining wall, fill, and then have that as the, you know, the top level, I don't know. But I'm asking that they stay within the dimensions of what's allowed. 30% of, and if you measure the lot at the back of wherever the house will be, changing the position, instead of the house facing directly parallel to Patton Circle, if you turn it some, you get a bigger lot line across the back, which would allow a bigger house. But
we understand the alternatives. We understand that.
So my objection, they keep talking about the 15-foot. That is not an issue, sir. It's the width of the house, the size of the house. That is the footprint of the house is the issue. and the closest to my site.
Okay.
All right.
Just for clarification, reorienting the house, I'm going to read the protected ridge overlay width standard to clarify.
Before, if you may.
Well, I'm going to clarify this and then.
Oh, I thought you wanted to speak.
He's just
after
making a-
everyone else talk.
I'm just going to go ahead and clarify this if you don't mind.
Give me the last word.
Sure. I think this is important for the board to understand this definition that's under debate. Building width in the protected ridge overlay district shall not exceed 30% of the lot width as measured from the at the face of the building oriented to the downhill section of the lot or adjacent topography and parallel to the crest of the ridge. So there would be very minimal effect from rotating the building. It's a function of topography more than anything else.
Gotcha. Thank you.
If I may, I think that this was the, you
Sir,
all have it.
you need to speak
I
into the
beg your
microphone.
I thought I was loud enough. All right. You have this in your package when they applied for the variance, and I think to show the arguments that I think Mr. Friedman and I are trying to make, and frankly, Mr. Bryant for that matter, you can see superimposed in here the extent of the violation of the 30% rule. And I think what both on behalf of the Means and Mr. Friedman, if you want, it shows what they're really asking for. If they could turn the house or if they could cascade it down the mountain, this idea about it's so steep, but it's not as steep at the bottom. You can see the topo lines, that if they put the house down, they could come up. But primarily, it's the nature of what they're asking for. They're really trying to jam something in a space that was never intended to be used this way, and there are options or alternatives, all of which would conform to a request by the property owners, but would satisfy the adjoining property owner. And from your standpoint, we would submit, would comply with what the intent of the ordinance is, because you can see the impact that this has compared to what your ordinance would require. And that's all we're asking is the extent of the variance, or to consider that. This simply could not be built here without a substantial, more than approximately 50% of the house would be within what the ordinance would provide. To me, that's a substantial request for a variance that could be adjusted either by turning it, moving it down, or there are options, all of which was exactly the condition of this lot when the people bought it. So, thank you.
Okay.
I'd like to address that if I can.
Okay.
I think since he's the applicant, Mr. Chair, since the applicant should have the last word, so I would.
Keep it brief.
This is a
I'll
wrap.
allow it, yes, of course.
Keep it brief. There are other things that we could do, but they would trigger other violations of the ordinance. Impervious area, height, building height standards. So again, this is the least impactful, and unfortunately, it does ask for a variance for this portion of the zoning. But to push it to another part of the site or to make a narrow house that's taller, we would be violating other parts of the ordinance. So it's there's conflicting provisions of the ordinance working here. So I'll just close with that.
When you say that's least impactful, that is strictly your opinion, right?
Well, the amount of trees that have to be cut down if we push the house farther down the hill, and we have to have a driveway to
Okay,
access.
that's not answering my question. That is just your personal opinion.
I could show the math.
I
It
know,
wouldn't be
but when you say it's the
opinion, but
least impactful,
it is my opinion, yes, but I could also show the math that would make it factual, if you will.
Thank you.
all right. Jillian, is that everyone?
Yeah.
Unless, is there anyone else who wants to speak regarding this case? That's it.
Close.
Okay, at this time, I'm going to close the public hearing. Discussion?
Well, I guess my question is, because I'm not gifted at these maps, is does anyone see we have a professional saying this is having the least impact. Does anyone have any alternatives to that? Does anyone see, visualize, or anticipate ways in which it could be done in which has less impact? Since this is a variance, and that does seem to be an important part of it. George, you usually have an eye for things.
No, my only observation is that this will have a somewhat dramatic impact on the complexion, the decade-long complexion of this development.
Yeah.
It will have that, but I don't see a better way to do this. I think the applicant has a right to do this. And it's not a perfect solution, but I don't think there is one.
Okay.
If given tract A on this site plan is the only area in which they could build a house, I don't see how they could build a house without some variance on some level.
Yeah.
Okay.
That's a question I've had. Is tract A the entire tract? Or is it just that area
That's the buildable area.
That's the buildable area.
And my understanding is that's the singular
What is
platted
the
tract, but
approximate acreage of this tract?
0.48 acres is what it's showing on the site plan.
The whole thing?
Of the whole thing, or of the?
That's what it shows under
It
the
can't be.
description of tract A.
This is just,
I
Should
think
be
it
in the
is,
application as well.
It looks bigger
this,
than that.
this
It's only 100.
dashed
It
line
looks bigger than
area.
that to me.
It could be,
Is the
but
buildable area.
That's your slash line.
I think
That's the buildable area. on the
buildable
lot.
area.
it's
What
0.48.
is the area of the lot?
Yeah, that's the area of the
That's
lot.
the, .48 is the entire area of the lot, but this hashed area
Right.
here is where they could build.
But this, the way
For
that
the
was said,
30%,
right, this is less than a half-acre lot.
this
Right.
whole lot is less than half an acre,
Yes.
yes. No. No. This is the house
Further
that
comment?
has been built. This is a variance.
We're at the point where we need a finding of fact.
This is a variance.
Well, but was there going to be a staff wrap-up? Did I hear a final?
I mean, pending any questions from the board, I think we've heard both sides of the case. And unless there are additional clarifications that we can make regarding the interpretation of the protected ridge overlay, because I know both the board and staff has not had much experience in discussing that in this format, so we want to take some time with that.
And if you wanted me to read the requirements for a variance, I'd be happy to do that, but I think we're pretty aware of.
Yeah.
I think we're aware
Yeah.
of that. I'd make a motion that we approve this as filed.
We need a finding of fact, George.
Yeah.
Either to approve or,
Before we do that, why don't you verify that all the information that's given?
Right. Good point.
I usually do that after the finding, but okay. That gives somebody an opportunity to speak up if we're really off. Okay. Okay, George, you want to get the script there and?
Yeah, I'm just, if I've got the right page for this.
Okay.
It's,
Based on
there was two, we got, page 1 of 4 is the correct pages for this?
No, right here, right here.
The worksheet
Yeah,
should
I'm gonna
be
do
ZPH 2012-6.
Top
And that should be in
right-hand
the
corner.
top left corner.
006, okay, I've
Or
got
top
it.
right corner.
Okay, because I know there's the follow-on is the vested. It's a
Yeah,
complete separate
we
thing.
still have to address that.
Okay, I move that this board adopt the following findings of fact. Well, let me start. Mr. Chair, based upon the evidence presented to this board, including the following exhibits, the petitioner's application, the submitted development plan, the GIS maps, the finding of fact worksheet, and other documents that were presented, I move that this board adopt the following findings of fact. Numbers 1 through 7 and 8A, this application does meet the requirements for granting a variance by demonstrating an unnecessary hardship on the owner for the following reasons, A through G.
All right, is there a second?
I'll
to that?
second.
Okay, there's been a motion and a second to adopt a finding of facts.
I
All-
have a question.
Okay,
are we going, within this motion is number 7.
Yeah,
Shaded.
we're going to cover that.
Can you cover that?
That's a good question for me.
Yeah.
Well, we're accepting
Should it
all
be
the
included?
finding of facts.
Should be included in this
It's a separate.
motion?
It may not be,
Or
no.
should we stop at 6 and then do 7?
I guess it would be up to whoever's making the motion. If you want to include it, where basically, under the law, when you grant a variance, you have a 2-year opportunity to construct your home. What the applicant has asked for is an extension of 5 years, which may be granted by the board. So if you want to address that issue separately, we can.
Point of
Or-
procedure. Are we, because of the agenda created, are we going to have to bring up the vesting as a whole separate flow and procedure?
Yes, that's a second
a
part.
separate motion.
If we have to, then let's delete
George,
some.
I would ask
Right.
you to amend your motion to take out 7.
So
which is-
amended.
Yeah.
Okay.
And do this.
And I'll second it.
Okay.
Okay.
All in favor?
Aye.
Opposed?
Yes.
Okay, we'll handle that, the vesting as a separate issue. I think that makes
Right.
it
Cleaner.
more clear. Okay, to the to the presenters out here, anyone who came up to the microphone, is the information you have provided to the board true and accurate to the best of your knowledge and belief?
Yes.
Okay. All right. Let's address the applicant is asked to have a 5-year vested right.
We got to
Hold
do the
on.
variance
Let's
first.
grant the
Okay.
variance.
Yeah, we have to
All
vote
right,
on
we can go
that.
ahead and do the variance.
George, you want to go?
George, you want to do that second?
And then, based upon the foregoing findings of fact and for the reasons set forth therein, I move that the requested variance be approved.
Okay, is there a second to that motion?
I'll second it.
Okay, there's been a motion and a second to approve the variance. All in favor?
Aye.
Aye.
Opposed? Hearing none, let it show that there's unanimous vote. Okay, now to the vested right.
Do we have a ZPH form on that?
No, we
No,
don't.
no, that's just a straightforward issue
It's
of
an up-down straight.
up, down.
Just a,
It should be in your, in the applicant's documents. It's page 1 of 2. It's the application for.
it's not in here.
Okay, gotcha.
Yeah, it's in the thing. I think 5,
Okay, I see it.
my opinion is 5 years is much too long. You have to make up your mind if you're going to do something, to do it. 2 years is allowed directly in the ordinance. Sometime this board has granted 3, but I don't think we've ever, in my.
Yes, we have. We've done 5.
We've done 5 in a
We've done
couple
many
occasions.
5s.
Yeah,
And
I have
Mr.
five.
Chair, if I could just, as a point of information, this is not meant to direct you in one way or the other. But up until December 31st, 2011, the state of North Carolina did authorize a Permit Extension Act, which pretty much grandfathered permits through that period and stopped the clock on all development permits until the end of last year. So it's not something that's uncommon in today's financial market. So that is worth noting for the board's consideration.
Let me just read. Basically, what you need to do is have some finding that that the duration, that there's some relevant circumstances that would warrant an increase in the time for the vested right period, and that's including but not limited to the lot size of the development, the level of investment, the need for or desirability of the development, economic cycles, and market conditions. These determinations shall be made in the sound discretion of the Board of Adjustment at the time the specific development plan is approved. So you've already approved the development plan. So now it's just a question of whether you think that, given the circumstances, a 5-year would be appropriate.
How close are they to retirement?
They live out of state.
Sorry.
They live out of state at this point, and moving up here is contingent on selling their house in Dallas. have every intention to build within the next 2 years, but given the past 3 to 4 years, things happen. So they're fully committed to building here for their retirement home.
So the only reason that they want to wait 5 years or have that extra is just in case their house doesn't sell.
Correct.
So it's just economic factors.
And given precedent in the past 4 years.
I probably don't think this would apply, or, it's, again, under our purview, et cetera, but the one question just comes in my mind is, I've seen a few properties where someone starts to build, and it goes fallow for a little while, and because of the vulnerability of the land and the area, that could become problematic. So when I'm thinking about 5 years, I'm thinking, well, if they start and they start to do something.
They have only 2 years after a building permit to complete.
Okay.
It's not a building permit.
It's not a building permit issue.
Once the
Right.
variance.
Okay, so
The
what you're saying,
zoning
once they
variance is
start,
granted
they have
for
a small
5
window.
years.
Okay, that clarifies it.
What basically you're ruling on is that since you've approved the variance, that their specific site plan, and that's what the survey, that right now legally they have under North Carolina law and under our ordinance, 2 years to build that property.
Right.
If they don't start construction or do something within that 2 years, then their variance goes away. What they're asking for is an extension of an additional 3 years, which our ordinance does allow, given the showing of economic.
Right. And so my thing, though, is once building starts, the window does tighten up. So.
At that point, once building starts, our permits tie directly to the permits from Buncombe County permits and inspections.
Yes.
Then I'm fine with,
Legal question, it's either 2 or 5.
No,
I mean, we automatically gets 2, but any extension.
It's 2. It's a question of, they've asked for 5.
Asked for 5.
Yes,
You could do
in
3.
your
We
discretion.
could select the number. We could say 3 or
Right.
4.5 or whatever is our
There you
choice.
You could, yes.
Ain't that big a deal.
Yeah.
It's just, I think we should give the man 5 years.
I agree.
Because of the
reason I say that
economics
is, and I do respect that you're thinking on the 2, but we're in such a flat period.
Yes.
That the 2, that's a short period because of the practicality
Right.
of
And
everything, the finance.
Selling property is tough all over, but definitely a state like
I would support the 5.
Texas is increasing.
Okay, I would hear a motion to,
I make a motion to grant the vested rights for 5 years.
I'll second.
is there a second?
Second.
Could you also just make a simple finding based on the economic realities and the current market conditions? I think that would be sufficient.
Can we just make that a part of that motion?
That's what I'm asking.
Yeah, okay, rather than go through, we don't have to do a finding.
No, you don't need
Yeah.
to find, I was just as part of the motion.
Okay.
Right.
Would you so add that to your motion?
Yes. I motion that based on the finding of fact that the intended construction may start delayed due to economic volatility, that we grant them a 5-year vested right on the variance.
Okay.
Second.
We have a motion and a second to grant the,
Seconded that?
just assume he did. Okay, we have a motion to grant the 5-year vested right. All in favor, say aye.
Aye.
Opposed? Okay, let the minutes show that there was unanimous vote to support that.
Privilege, 2 minutes.
Yeah.
All right.
Yeah.
Well, let's take 5.
Yeah. 5
2
minutes.
minutes is pretty specific.
Blood moving again.
Mr. Chair.
Be really specific. Okay, we could miss.
Hey, if we could ask everybody that's with the wards, conditional use permit, if they could move up to the front to kind of expedite the public hearing for this next one, so that everybody's in the front
Okay,
row.
did everyone hear that?
If you couldn't hear it, you need to move forward.
Very, very bad. Okay, nice to see you again.
To be technically correct, we use that term volatility. It's a lack of economic volatility. That's why we're passing that.
Well, yeah.
There is no economic volatility.
Well, let's see, what did I do with my script here, man? I'm gonna be out of, oh, here it is. I put the, okay, number 91 is coming up here now. Is that this is the right one? Yeah, this is Bryant here. This is Here we go, yeah.
Okay.
I got excuse, sir.
See, Jessica has time to call him back. Doesn't. Just tell her, yes, we can do. We can contact
Well, I know what was done.
Okay. Okay, and I understand that, but
Okay. Okay, thank you.
I just wanted to know what the parameters were, because you're the chairman and you can allow anybody to speak. Make sure you talk to each other. That's not my number, so I just wanted to know what the parameters were. Okay, good. And you have the emergency access. Right. Like you're going to open that one for emergency access. It's my own site, and that's our primary access. I understand.
Is it that one or this one?
Oh, no, that's the next.
Yeah, that's the next one. It's this one. Here's that, and here's, but I think roads on this.
That's fine.
Let's do that.
Do you want to keep them, or?
Yes, if you don't care, I took these two. I'm a note taker. I'm a note taker.
He's not coming up to answer us.
See, now I would have said no if you had not said that there was no other place other than if they had, they were going to have issues.
They're going to, and that's what I was
What's the big
saying.
deal?
This is the 30% line. Even if they turn the house sideways, Robbie.
It's not gonna-
It's not, it's
they're
like,
gonna have to-
the house would be like 17 feet wide. It's a mobile house.
But that's what I was going to say. That was the only reason, because I don't know enough about it. And if that was the case,
I mean,
then why would you?
anywhere, they, other than rebuilding here, which, like they kept saying, they can have two houses.
Yeah, and it's
Other
not
than
up to us
building
to tell
here,
them they have to do that.
Other than building here, they have to build in this little bitty sliver, and anywhere they put a house, they were gonna have to have some sort of variance. And what he was saying is, once they go here, then they get into the height requirements for steep slope. And what this guy was saying, well, you know, traverse the driveway and build it here. Well, you can only, with this lot size, you can't have that much impervious surface, because house and driveway go into that calculation. They're minimizing the impervious surface by doing the site plan, because they've got the house here and the driveway here. This is all they're disturbing on that lot. That's the minimalist, invasive. That's
So
it.
it's not like they're disturbing all of that other
They're all,
than
this is all they're disturbing.
So basically, that's just don't want these
Oh, no, he doesn't want them to block their view, and neither do the other people. To cut their trees down. But there's 22 feet still in between the lots. Look at Belmont Park.
Also, and that's the truth.
You know, I mean, I'm sorry, but if they didn't want a house built there, they should have bought the lot.
That's exactly what and that's what I was going to say. But just for no reason. I mean, if there was
I think it's just declared across
Oh, I
the board.
know. If there was any other way, I know.
especially after they said we couldn't consider the second house.
Yeah, I know. That was the kicker for me too.
Once they
Because
said
I would
that,
have been
then
like,
you're
tear it
just-
down and build another
Me too.
house.
What
but
kind of
then-
accessory
yeah.
structure are you talking about?
I know.
But I think each
Not up to me.
Me either.
I did not.
Yeah, we gotta get started. Where's our chairman? Chairman,
I think we need to order out.
we gotta go.
We guys want Chinese?
We gotta get going.
Massage.
Oh.
So what was the record?
We don't govern anything less than 12 feet on one side.
I was out of the concrete.
Except if you go to like,
Was it like midnight one time? Yeah, that I heard was midnight.
that's not subject to setback.
We started late.
What time? Started 5?
What's any one side?
About 5 o'clock? But it went midnight to 12.
Okay, let's call this one.
Let's go.
Okay, we're ready to roll again.
I believe it's 10 feet, but let me.
Recuse myself.
Okay. Okay, we're ready to go once again. Okay, on number 91, Josh.
All right, Mr. Chair, this is ZPH 2011-00091. This is a continuation of the case where Robert G. Ward Jr. has applied for a conditional use permit to site a travel trailer park pursuant to Section 78-677 and 78-678, Section 8 of the zoning ordinance of Buncombe County on a portion of tax lot pin number 9689340595 at 45 Wards Lake Road. You should have a copy of the revised concept plan in front of you, as well as the floodplain maps. I will say that both Cynthia Barclow, the county's floodplain administrator, and myself have gone out there to address some of the concerns that the board has. And you'll notice some reorientation of the sites from the last plan that was submitted to kind of account for the position of the floodway. At this point, I think Cynthia is comfortable with moving forward with this plan, but they would still be required to meet all the provisions of the floodplain damage prevention, or the flood damage prevention ordinance. And I'll just have the Board of Adjustment, I think Ms. Stanley can speak better to this than I can, note that in terms of the buffering issue on the side of the proposed travel trailer park closest to the Swan River, there is an earthen berm there, as well as substantial native and natural vegetation. And I believe that would satisfy the buffering requirements for the board, but the board will need to make a determination of that. And Ms. Stanley, I believe, has photos of what that looks like with foliage on it.
It's all right. Who's going to be presenting? Was it Liz? Lynn.
Okay.
All right, proceed.
Okay. I believe you have we hired a surveyor, so he put in the lots and sizes. Do you have that?
That's showing 7 lots, right?
Mm-hmm.
Okay.
Yes. And it should also show where the sewer and the electric is on there.
Yes.
The site boundaries, I believe, was one of the topics you wanted us to address. The entrances would be, you come in from the same entrance that's always been there. There's a gate on the back entrance, and there will be people with 3 keys that they'll be there at any time in case of emergency, that has to be open to move it out. And also, we can even give a key to the fire department, in any kind of emergency, that they would also have it if that's would make a requirement. Or there are plenty of parking areas. Even when you pull a camper into each space, you could probably fit 2 vehicles plus across from where the camper spaces are. There's like a little, you'll see a dock, maybe see that on there. There's additional parking there also for guests or any. And there's only 5 electric and sewer right now. you know, maybe later if he wants to do the other two, you know, and if you approve the 7 sites, then he can do that later, but there's already
So
pre-existing
you have
electric.
utilities in place for the first
Yes.
5.
Mhm.
Yeah, 2 don't have utilities.
Right.
Okay.
Where on this drawing are the entrance, your gate, entrance and exit gates? You said that you had 2.
Yeah, the first one, it comes in off of Davison Road. It cuts to Springdale, and it doesn't show that on this one that I have. I don't know.
So you're saying there's really only one entrance?
Yes, the other one's always been gated off for years and years, but there is a lock on it with keys, and like I said, there would be 3 people with keys at all times, and if the fire department needed one, we could also furnish them with one.
Okay, and the information you supplied, you said that hours of operation will be from 7 a.m. to 10 p.m. Camping will be per day or weekend, but no longer than 180 consecutive days.
Right.
How is that enforced? How do you know that? What
I
happens?
guess with the contract, you know, when if
Yeah,
somebody
but,
wanted to come in with.
That says to me that there can't be anything rolled in one of those lots and stay there longer than 180 days.
Yes.
Well, I believe, if you remember from last time, I think it's caller enforced, right? If there's a
Complaint,
complaint,
yeah,
is it?
but-
That's not the applicant's provision. That is a provision that stands within the zoning
Right.
ordinance. For
Okay.
any time you have a travel trailer used as a residence on a piece of property, and that is complaint driven.
Right.
Okay, well, I understand that, but this is their submission here, and that's what they're saying, and that's why I raised the question.
Yeah.
If that's the agreement we're entering into here.
Would you have a lease in place that would limit them to 180 days?
Yes.
So you would follow up in your system and of contracts and so forth, and after 180 days,
They would have to move.
they would have to move.
Yes.
They might only have to move to the next lot, I suppose, but they would have to move.
Right.
Okay.
Yeah, and we would not allow, it's off the property. So, I mean, they would have to move across a pin line in order for it to count as a move for our
Okay.
purposes.
Okay. Any other questions of the applicant?
And I have some pictures if you guys would like to see where the berm is on the property for the buffering.
If you give it to us, we keep it.
Okay.
Get your picture.
Mhm.
Not a picture perfect.
Because the grass, the leaves and everything have grown so much, but that's the top of it with all of everything. And it's about 6 feet to 8 feet tall and about 50.
Okay. Oh, that's the burn back. I got you.
Ma'am, if you're gonna speak to them, you need to speak into the microphone.
Yeah, so the line,
Oh,
you can see like
the-
a pen mark.
these are
That's-
holes.
That's the berm
Yeah.
area. Here's one more.
There's just so much foliage
Oh, I
now,
see.
it's hard to see exactly.
I guess everyone's got one of these, yeah.
Okay.
Oh, I see it, yeah. Oh, I see what you're talking about.
Okay. Is there anything else you want to tell us? Is there any questions for the petitioner?
I think that's everything that you guys wanted us to address.
Right. And all I'll say is that this is extremely helpful,
Yeah.
as opposed to the last time I was lost. This is nice.
Want me to?
All right. Fine. Jillian?
The first person on the list is Doug Dixon.
Thank you. Doug Thigpen. I reside at 198 Davidson Road, which is on the other side of Davidson from this project. I have really just one concern, and I think I heard Mr. O'Connor beginning to address it, but I'd like clarification if I may. He said something about a reorientation of the lot lines to take into account the floodway boundary.
That's been done on this.
Well, the one that I obtained from him last week does show, if you'll refer to yours, adjacent to sites 1, 2, and 3 is the back end of those lots is the floodway area limit, but the earthen berm is considerably farther east of that. My main concern is that, since one of your findings of fact is that it won't result in damage to property, that if the folks that are renting those sites do the natural thing and push them back all the way to the berm, they're in the floodway.
And to address that, I wish Cynthia was here to speak to that specifically, but there will be some permanent manner of marking, whether by impenetrable fence or trees or something, so that there couldn't be any kind of inadvertent or unsupervised access of a vehicle or the mobile home or RV.
That's my concern. Thank you.
We have another person who wants to speak, but I cannot read their hand.
It's Jackie.
Hi, I'm Jackie Pennick.
What was that last name again?
Pennick, P as in Peter, E, N as in Nancy, I-C-K.
Okay.
I am a neighbor. I live at 10 Prominence Lane, and I have no aversion to this at all, just a concern. If you look at the application under Part D, my main concern is, I'll start with point B, there will be no substantial increase in noise and traffic. I would like substantial clarified a bit. Let me just point out, if you look at the map, the greater, the broader map that you have, it is true that there's a berm and the river and the pond, but what this doesn't show very well is that up above on one side behind the pond is a hill, and there are now 4 homes up there with 2 more that are to be added. This is zoned residential area, so I do have a concern about the noise possibility rising as noise does up on the hill that's behind to the homes. Second concern related to that is the hours of operation for the office will be 7 to 10 p.m., and that is point J. So I would like some reassurance from the applicants or some guidance on what the residents might be able to do if there is a concern of noise after the closing time, when after 10 o'clock is the time when often there is difficulty. If there's noise during the day, it is when people are awake, or hopefully awake and not trying, but in the evening time is a concern. So that's really all that that I have to say about that. And because also in J, camping would be per day or per weekend, there could be potentially a lot of people coming in and out that have no vested interest in the neighborhood as a residential area, and just wanted to express my concern. Thank you.
Thank you.
In terms of the noise from a nuisance standpoint and exceeding standards of reasonableness, that's handled through the Buncombe County Sheriff's Department, who does administer the noise ordinance, and they would be responsible for enforcing any of those noise complaints. Other issues of potential impact to the neighborhood, including the installation of lights, the applicant has addressed that concern specifically, and that there will not be any additional lighting installed with this conditional use permit.
Right. So this still falls under the complaint driven, that someone would have to make a telephone call to the sheriff's department. That's what
I mean, there's really no way for us to actively monitor.
Yeah, I know. Yeah, that's what I'm saying. That's so that for the understanding of.
And the other noise issue that was brought before, and there was reassurance given, was There was some issue about someone previously doing advertising and a bullhorn and things like that. You gave assurances that was not going to happen, right?
Also, my uncle would make sure that after 10 or 11 o'clock at night, most everywhere you go, out of respect for everybody else, you have to tone it down. There would be no loud music, nothing like that, and they could
Then
probably have a
that's-
phone number to contact anyone if there is loud noise, if they would like.
Okay.
Okay, great.
That seems
Thank you.
straightforward.
Is there a manager on site?
Yes,
24 hours a day?
yes, there is.
Okay, great.
And just like with any nuisance complaint, I mean, it's an escalation, If it becomes a continued complaint, then there is intervention at an administrative level beyond just simple sheriff's department response. It's not
Okay.
just going to be send them out over and over.
This may already be in here somewhere, and I just am overlooking it with all this. So is there something posted that says rules, like no, like a,
Yes, I can draw him up.
And then that way
rules,
they
and
have
then,
some way-
There's also speed limits around there, so they would be no loud.
well, and then that way whoever's bringing in their,
There is
their
posted speed
travel
limits
trailer
at
and their
7 miles per
friends.
hour already, so there won't be any,
okay, and then that way that would give them some idea of what
Right.
they.
can and cannot do.
And you obviously will have policies for violations of the rules?
Yes.
Okay.
Any violator must attend a Board of Adjustment meeting.
There you go.
That was it. unless
Strapped in
anyone
a chair.
else would like
Is there anyone else that would like to speak? All right, I'm going to close the public hearing at this time. We need a finding of fact.
Mr. Chairman, based upon the evidence presented to this board, including the following exhibits, the petitioner's application, the submitted development plans, the GIS maps, the findings of fact worksheet, I move that this board adopt the following findings of fact, numbers 1 through 5 and 6A through M.
There's been a motion to adopt a finding of fact. Is there a second?
I'll second it.
Somebody didn't hear
Oh, someone did?
I'm sorry, I didn't hear you.
Lisa?
I
Lisa
just-
got it.
Okay.
Sorry, should speak louder.
Okay, is there any further discussion? Okay, all in favor, say aye.
Aye.
Opposed? Okay, unanimous motion. Okay, to the presenters. Is the information you have provided to the board true and accurate to the best of your knowledge and belief? All right, Peggy, we need,
Based on the foregoing findings of fact and for the reasons set forth therein, I move that the requested conditional use permit be approved.
is there a second? Okay, George seconded the motion. Any further discussion? All in favor, say aye.
Aye.
Opposed? Okay, unanimous motion again. Okay, thank you, folks.
Thank
I
you.
didn't get a chance to say I'm a happy camper.
Oh, man. There has to be one in every crowd, right?
I was like, come on.
You should have jumped in there.
I was going to say, with all this extra information, I'm a happy camper.
That's it.
Moving right along.
Oh, that sounds excellent. Excellent. Excellent.
Okay, well, let's take a break.
Yeah, 5 minute snack break?
Sure.
Or snacks. Let's do it.
The
Okay.
snacks are out.
Okay, your friendly board is going to take a little break here.
Break here.
Seems that we went over the noon hour.
That one's mine's quicker than I. I'm feeling better.
Me and you both. Sweating. I am too.
We spent many an hour camping, so I can appreciate what they're doing. When they were here before, they just didn't have their mess together.
sure, and I know him from somewhere, and I just cannot figure out where. I wonder if there's something to drink out there. Of course, I'm thinking I get something to drink. Excuse me, it's hot in here.
Sometimes she has stuff to drink. I don't know if she has anything to drink.
Hopefully a snack. I just want to
I stuck a packet of crackers in my car. Each one was going to the gym, so I don't really need.
I'm gonna keep mine if that's all
Okay.
right.
Do you have
I'm the
anything
note taker. I look back at mine. Oh, she found something to drink.
Yeah, there's
I just
Peggy,
want
if
something
you're
to drink.
hungry or if you want something to drink, there's stuff out there.
I don't want anything.
Okay.
I am too.
Is this all
That's all.
recycling?
Yes, ma'am. Phew. Does the gentleman, come often?
Fred Friedman, all the time.
Okay.
We all know his name.
Thank you. I figured he did.
For numerous hours on it.
He needs a job.
No, what he needs is about 6 to 10 inches height.
Uh-huh.
Really?
Yeah.
Because so often people,
I'm only this tall, and people listen to me.
No. Men of that stature.
I agree. You're right. He has short man
Uh-huh.
complex.
Uh-huh.
Yes, Napoleon complex. You're right. You're right, Peggy. Absolutely correct. Yeah.
We have a closet.
Yeah. He splurged for snack.
He just didn't know it.
Where was it? Is that a male dominated complex? He my career was sort of male dominated.
Oh.
I was the only woman in the department, so I could.
I'm sure you probably could almost.
I could pick them out. Which one's going to give you trouble?
You know,
Jesus.
my
You can't even put a trailer there.
I mean, we
I
spent
was
some time
married
just playing with
25
that
years,
after the meeting.
and my husband, God, was only 5'5". Well, he said he was 5'5". I think he was really about
it
5'4".
changes, like, you can move the setbacks by how you
He was
rotate the
much
house,
more
but it just be
quiet
a
with
strange shaped
his-
parallelogram.
Right.
He was very forceful, but he was not as, he was, he lived on adrenaline anyway, race car driver, that kind of thing, and so.
Are they asking us to prove one option or the other here?
Jet pilots and maybe. Shorter than.
Oh, I didn't even think about that.
So they're not asking.
There was a difference between them and C-130.
So they're recombining the 5 lots.
Oh, the
Oh,
mechanics.
there's 6 and 7.
My son works
Seven
for, my
lots,
older
and
son
they're
works,
recombining
has
the
just gone to
lots.
work for an aviation,
They're recombining.
group out of,
Three houses.
North Rock. He knows nothing about
So
it. and I'm
Josh,
surprised that they hired
Just to
him.
be clear, they're asking to build 3 houses on 7 lots.
They're doing a recombination.
Military contracts.
Thank you.
They have 20 planes, but 15 of them are usually going. and they have their own mechanics and things, but they do a lot of jumping, what do you call it, like skydiving, and they do a lot of jump schools for the military, and they also do some, they have these booms that are out on, these survey booms out on the plane wings, and they go into different places and they do surveying way below, like for oil or type of natural resources. And Trip is their records manager, which you have to be so meticulous for every little nut, bolt, everything. And he actually is doing well with it. Ever that he would be that meticulous with paperwork and stuff.
Oh, gosh.
Doing okay with it.
I'm wondering if that,
I don't really know. It's called Rampart Aviation, and I'm not really sure what it is. FAA
Well, it was nothing compared to what we were talking about when the concrete plant was before us.
what you're saying to sound.
We started somewhere between 3 and 5 in the afternoon.
It's about 5-ish. It was 4:35.
We were here past midnight. And that was what, the second of the 3 meetings, wasn't it?
No, it was the final.
Was it the final?
That was the final meeting. Yeah, we have an unlimited number of times we can push the meetings back. No, that's not true. No, we don't do it that way.
Right.
Yeah, that's what I heard them say.
Mm-hmm. There is no there's no perfect way to situate all of the things around that makes everyone happy.
We don't have enough flat land.
That's the dilemma that
Oh, is that
every group, every city has, every county.
And they still have to have variance.
Hey, they're having the same problems up there, though.
And who is it?
Morgan Ranch, Morgan Road, off
Out
of
near
Morgan's
me.
Ranch Road.
They're one of our offices. I thought that's what I just said.
This is crazy.
That clock is really bothering me.
Yeah, it looks like they're tiny.
It's moved a little bit.
It's our advantage, we don't have to even start, it's not starting.
You know what?
on yet.
It's not only behind, but it's very slow.
Yeah.
It's- It only we've been there
Moved like
about
30
2 hours.
minutes since we've
Only
been here.
moved 30 minutes. You know, we ought to take that. Maybe there's a way to, if we put it in a smaller room, our lives would go slow.
Yeah, it's kind of the,
All right, I will call us back into session at 56 minutes after the hour.
All right, Mr. Chairman, the last case that you have before you today is ZPH 2012-0002. This is a continuation of Danny Whitted's application for a variance from Section 78-642, dimensional requirements and setbacks of the zoning ordinance of Buncombe County to site single-family homes on tax lots 9608702450 at 3 Naughty Alder Court, 9608702355 5 Naughty Alder Court, 9608702340 9 Naughty Alder Court, 9608703359 4 Naughty Alder Court, and 9608704308 6 Naughty Alder Court. Before the applicant begins their presentation, I will note for the board that this is a significantly modified application in that they have reduced the number of lots that they are requesting a variance for, and that it's going to take it from, I believe, 5 proposed lots down to 3. So it is different than what you looked at the first time. Some of the geometric concerns that you'll note, such as the lot depth, still remain the same, thus necessitating a variance even with those substantial recommendations.
Could you, point of clarification, could we get a sketch or a description? There is 1 or 2 existing homes that aren't shown on this plat. Is it at least 1?
there's 2.
It's 2.
2. And where can I?
George, the aerial photo should show those 3 homes that we sent you in your
Oh,
packet.
that's right. Now I remember. Yeah, remember the,
We got through the whole meeting without having to pull out that back. There it is.
There's a nice drawing in the last one in there. It shows you exactly. Much improved, gentlemen, much improved.
So wait a minute now, we got Naughty Circle.
Okay, everyone settled here?
Yep.
Let's go for it. Okay, tell us what you're gonna do.
All right, to review this, we've put a proposal into the bank to buy the remainder of this subdivision that is, the original developer went under and it has returned to the bank. The setback requirements have changed in the meantime. So we have to have a variance in order to build on these properties. Last time we were here, you asked for some kind of a drawing showing what we could build on them in compliance with the new setbacks. I have drawn up a sheet that shows each lot and the size of house that could be built on them.
And just to clarify for everybody, so we're all looking at the same sheet of paper, it's titled at the top in red pen, current setbacks, and then in green computer font, existing lots available for building with new setbacks.
Thank you.
Okay, and you can see that the lots do not go clear to the street. For whatever reason, when they were platted out, they do not go to the street. So they're set back 14 feet from the street. I think it was the original intention maybe for people to park in that 14-foot strip. But at any rate, you can see that what's available for building, because the lot is only 50 feet 8 inches deep, is about 10.5-foot wide strip, which is as wide as most kitchens. So without some kind of a variance, none of these lots can be built on. Okay, so that's that one. We've talked to some of the neighbors, so we've tried to address some of the concerns that we heard last time. And so we've looked at it and tried to come up with a solution that satisfied a lot of the concerns, one of which was the one lot being on a curve, traffic could potentially slide off the road if it was slippery and hit a house or whatever. So we've combined some lots. We've combined this lot and that lot so that would just not have a house on that part.
Be out of danger's way, you should say.
Right. Over here, if we took 3 lots and made 2 out of them, we could abide by the 10-foot side setbacks that the current setbacks require. So that's what we've done, is we've tried to address whatever concerns that we could, but they still require zoning variance. What we're asking for basically is 0 on the front, but then you do have that 14-foot buffer to the street. So they're not going to be sitting right on the edge of the pavement, 14 feet off. We can live with the 10 feet to the side in the rear instead of 20 feet because the lots are only 50 foot deep. We're asking for that to be reduced to 10.
These are 1,100 square feet houses?
Basically, the houses that are on there are I haven't actually done the math lately to where I'm fresh on this, but it's 27
I multiplied it out.
Is that what it is?
100.
And what those are drawn out as is that's the same footprint as the 2 new houses in the subdivision. We're trying to keep it everything very similar.
Same character. Okay.
Okay, you were talking from an 8.5 11 sheet. Is there any significant difference between this and that when you were talking about the layout of the property?
No. We're
talking about the same thing then?
It's drawn to scale, transposed onto there.
Okay.
Good.
And Mr. Chair, just to clarify, as we go through making motions, if we could use this as evidence rather than trying to make a lot-by-lot determination, since several recombinations are going to take place, that would make it easier for us to take care of it from an administrative standpoint.
Okay, so we could address that in the...
In the findings of fact,
Yeah,
the front,
findings.
side, and rear setbacks.
All right, other questions
Yeah.
for the petitioner?
Well, I will mention too that in the combining of the lots, it gives at least 20 feet or better than 20 feet on the side of each house for parking off the street, which was another concern.
Yeah, but I'd say, that, I said that this is much improved from
Yeah.
memory of last time. I mean, it's, it's very straightforward.
Yeah, the way it was last time, everything had to be built exactly as shown on the plat. If you were off a foot,
No
it
wiggle
didn't
room
work.
at all, yeah.
Right. Plus, it gives a lower density to the housing, and that was another concern that people voiced, so.
Excellent.
Any other questions for the petitioners? Okay.
The first person I have is Tamara Gavin.
Hi, I'm Tamara Gavin, and I live in 8 Naughty Alder Court, the existing brick home on the property. I just have a couple concerns. I do feel like the solution is a lot more sensible, and I appreciate the effort made to, make a more reasonable solution. But I am sensitive to a couple things because, I live on the property. Well, I don't live on the property right now. I actually live in New Jersey, and I rent the property out. But just observing the dynamics of the space, because it is such a small lot, every square inch really matters. So I feel like it's hard for me to make kind of like a I don't feel like I can make an informed decision because I feel like this doesn't have enough detail on it, because it's just sort of generally sketched maybe where parking would be, but parking is a concern of mine. Just seeing how the existing homes and the cars that are there now, how they interact and how they have to pull out and things like that. And so for lot 3, there's a parking area indicated, but I feel like that area is concerning to me because it sort of interferes with the other parking areas, which aren't really indicated on this plan. So it's a little bit hard to see, but I guess I would like clarification. Is what we're voting on, does it like lock where the footprints of these houses? No, so those could be moved?
It just locks the setback requirements.
Okay.
Right.
Okay, because I would suggest reconsidering the parking for lots 3 and 1. And then on lot 7, I don't see where parking is indicated for that home. So I'm just curious about how that would work. And also just, so that's functionality. And then aesthetically, I also have just some concerns because, with this very small lot, I'm just curious where parking and where green space will be left, because already we've seen pretty much every tree on the property taken down. There's 2 oak trees left, but they actually were both killed and they're about to be taken down because the roots were damaged when they put in the road. So I guess I'm just sensitive to that. I'd like to see some proposed design for green space. That's it. Thank you.
And to clarify for the members of the board, in terms of parking requirements, the zoning ordinance just dictates that they provide a 9 by 18 spot of off-street parking out of the front setback. So it would appear that with the variance in hand, this is capable of doing that. The applicant is only responsible for providing parking for the lots that they will take ownership of and build on. So if there are other parking concerns that are generated by other members of the community currently where they might be parking across property line, that's going to turn into a civil matter at that point, where essentially what's happening is a trespass. There are no open space or greenery requirements that apply to single-family homes within this particular zoning district, as it is absent of any overlays. So I don't know that it would be a relevant factor in the granting of this variance, but I will defer to council on that.
Clarification.
Yes, sir.
If we approve this application, it will be that there can only be 3 homes built, is that correct?
The finding of fact that you have before you would dictate the recombination of those lots. Ultimately, they would still have the same rights to build 2 homes, but they would have to meet those setbacks. So I think it would be a logical impossibility at that point. And the setbacks that they would be granted would be those reflected on the site plan maximum.
Would it be out of order after our last discussion to ask the applicants if they have any responses to what Ms. Gavin's questions regarding the parking on Lot 7 and her comments about the trees that are no longer existent?
That if you want them to address that, that's your prerogative as the chair.
Okay, I knew, but just so we're clear, sir, I just wanted I would like to hear because I think she has justifiable comment there, so I'd like to know if you've considered that.
Where'd it go? Can't find my drawing for number 7. But there are 2 possibilities for parking on 7, and I didn't draw them in because I wasn't sure which one would actually work out better. This is the lot in question.
Ms. Gavin, you want to come up there and look at that?
Yeah,
so
we have them right here.
Yeah. Yeah.
They're part of our packet,
Yeah.
if you want to look at these.
Parking can either be on this side or in the front of this house.
Yeah. And there's adequate space,
Lot
but
seven.
I can see that here, but just so she's assured that
There exists a big oak tree right in the right-of-way of the road. I think by combining the lots, that house would be far enough over that we wouldn't maybe have to take the oak tree down, except that I think it's dead or dying.
That's what she said.
Well, that's what she said, yeah.
It
And
was dead
so,
already.
from a safety standpoint, we'd probably take it down.
Yeah, do you have any plans for putting anything like that back? You're not required to, but.
Maybe not an oak tree, but a tree.
Well, yeah, well, I'm saying that would seem a reasonable thing to do. Not required, but reasonable, right?
That's right.
Okay, did you hear that, Ms. Gavin?
Sorry, I'm trying to make heads and tails of these 2 drawings, so I wasn't.
Well, these gentlemen said that they will consider putting maybe a tree or 2 back there.
Okay.
Not officially, but, yeah.
I mean,
Somebody's heart.
a nice neighborhood, it sells houses too.
Sure does.
So-
Absolutely, you got it.
Are we ready for the next?
We're ready for the next.
Gary and Wilcox?
Hello. My name is Darren Wilcox, and I live in this development at the time when I bought it, I was lot number 4, so I guess that's been rewritten or something or another. But if you look at this layout, I'm up in the top right corner. And I guess as far as easements go, I guess I just ask that the easement be respected on my property line, on my shared property line. I don't have a lot of space. It's very confined back there. And I believe you were talking about parking while we were back there discussing the layout that was given to us. But the parking that's right next to my home, I don't have a pin, but I'd love to show you that there's a fire hydrant that's the city put in my driveway. So I literally can't park 2 cars in my driveway, or else I'd be blocking the fire hydrant and breaking the law. So I have to park up in front of the fire hydrant, which still technically blocks the fire department from the fire hydrant, but they can walk in the grass. Again, don't know why the city did that. But so I guess I'd like to understand how they're going to be able to get into their parking space and how I'm going to be able to park as well. Because these are, basically 2-car homes. Unless they have teenagers, then it's going to be 3-car homes, and it's a very tight-knit neighborhood already. I love the idea of what they're presenting. I really do. Anything that will bring value to my home and to their home, I'm all for. But like I said, in the corner and very tight and confined space, I literally have 2 feet between my house and the privacy fence from the adjacent home on the other development. So, I mean, and especially with fire concerns and whatnot, that's all I'm really asking. I don't.
They're actually not requesting a reduction in the side setback. The
Say that
10
again?
feet. They're not asking for a reduction
Okay.
on the side.
Okay.
And you're beside them, correct?
Yeah. Yeah, I don't know. I don't understand. I just.
Yeah,
kinda
I was just, so you know.
Never done this before, so. Hey. Am I on TV? Hey, no. Oh.
Yes.
But no, so that's pretty much my only concerns. I'd love more detail and more understanding of the parking so that my car is not blocking, or if they could just move the fire hydrant away from my house, that'd be awesome. And I could park 2 cars.
You're getting to an area that's out of our purview.
Yeah.
Where they put fire, putting it in the middle of a driveway, that doesn't sound very logical to me, but I guess things like that happen occasionally.
Yeah. So that's really all my concerns.
Okay.
Oh, and I'm sorry. I don't mean to take up too much more time.
That's all right.
Fine.
Again, it doesn't really lay out a bunch of information, but I just want to be helpful, and because I understand that you're caring people, and that's why you made the changes here. The first year that I lived there, there's some boulders right here at the end of the development, more as for decor for the development, I presume. But I saw a pickup truck run off the road, hit the boulders, knock the boulders around, take air flight, and land just below the tree that's currently there. So in other words, with this layout, you'd have a pickup truck in your living room. So that I don't know if there's a way to prevent if a boulder wasn't able to stop a pickup truck. I don't know.
Those boulders were put there because there's a culvert under the drive.
Yeah.
To keep people from running into this culvert.
Right.
But there's developments all up that road, and it's not a hazard.
That's on this part that we were gonna build on. What was talking about.
Here's where the boulders are right here. That's where the culvert comes under the road, and they've got the boulders right there.
So there won't be any building there anyway? Okay.
We talked to the postal service too, and if everybody would agree, we can all put the mailboxes where the boulders are, where he won't come into development, but that will get all the mailboxes off the side of the road, down here and up here, and put them all in the combined.
Centrally located.
We talked to those, but we hadn't talked to the folks that's in there about it.
Because
The mailboxes on that little particular spot instead of on 2 or 3 lots.
because I think that was a complaint that was registered last time about mailboxes being knocked
Getting knocked
over.
over.
Yeah, so, yeah.
I talked to them personally out there the other day about putting them in this confined area right here to where the boulders are.
That seems like a reasonable suggestion.
So that was the boulder, but that's to protect the culvert, not the houses.
I like the idea.
That looked good too. We're just trying to we're gonna try to make it look good, and by doing 3 houses, it'll value your house better. I'm gonna build exactly what's there.
Okay,
Water plant, both sides,
okay, folks, thanks for your cooperation and getting working that out. That's good. That's how it's supposed to work.
We have 2 other people on the list, but they're obviously not here. So.
Okay.
Too bad. Yeah, that guy was my hero.
All right.
Already.
At this time, I shall close the public hearing. Okay. Now we need a finding of fact.
Mr. Chair, before you move into your finding of fact, just from a legal perspective, I guess there should be some manner of addressing whether the trees are simply a handshake agreement between Mr. Woodard and Ms. Gavin, or if you're going to actually put that in the order.
In our recommendation.
What do you feel, fellow members? Should we?
I'm not for that. Because I think it's an economic item that it's clear and simple to a developer that thing that comes under the heading of visuals, everything would be something that they would be just a part of the thinking of the economic role.
Right.
It's a lot easier to sell a house with trees.
From a practical standpoint, I don't know how we'd specify it.
That's another reason I'm not.
Yeah.
I don't think, so
I
that's.
would also just state that this isn't a conditional use permit and it is a request for a variance. And really, a variance is not something where we can impose certain conditions, except for, lot lines and things like that.
Yeah,
So
right.
I don't think legally.
I think it was just to ask you to cooperate and do something that's right. That that makes sense, yeah.
I'm sorry. Got John did.
I did 3 developments in Buncombe County, and I've not got a bad customer yet, so we're doing things right.
Yeah, if you do the right thing, you'll come out right in the end.
That's right.
All right.
I move that I make a motion that we adopt the findings of fact.
Mr.
Chairman, read you.
Verification, did we ask if the verification?
No, we're motion for findings of fact, George, is what we're looking for.
All right, Mr. Chair, based upon the evidence presented to this board, including the following exhibits: the petitioner's application, the submitted development plan, the GIS maps, finding of fact worksheet, and the other items submitted, I move that this board adopt the following findings of fact, 1 through
1 through 5 and 6A.
1 through 6, and then
6.
7A, including the boldface that were reinserted. This application does meet the requirements for granting a variance by demonstrating an unnecessary hardship on the owner for the following reasons: B through H.
All right. You have a motion for you. Is there a second to that motion?
I'll second it.
Okay, there's been a motion and a second for the findings of fact. All in favor, say aye.
Aye.
Opposed? Okay, the motion passes unanimously. All right, to the presenters. Is the information you have provided to the board true and accurate to the best of your knowledge and belief? All right, now we need a motion to grant the variance.
I'll make a motion to approve the variance.
Is there a second to that?
Second.
Okay, there's been a motion and a second to approve the variance. All in favor? Any further discussion?
Yes. Are we going to include any wording about this map in this? Didn't you mention that? No?
The conditions were already included.
Yeah, they're in the package here.
I got you.
Who made the motion to approve?
George. Okay, all in favor, say aye.
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 Opposed? Motion's carried unanimously. Thank you.
Thank you.
Thank you for being brief. Okay, I will call adjournment, not on the county's time of 10 minutes to 10, but on my time at 21 minutes after 2.
21 after 2? I'm going to make my meeting.
Y'all did good today.
I'm not, where is it? I'm not going to miss it.